Welcome to another episode of the Lyceum of History, comparing common law and civil law legal systems. First, let's look at the historical background for common law. England in the 12th century was under Norman rule, and the Normans introduced a centralized feudal law code. It was really King Henry II who sent errant judges to hear cases throughout England. And as you can see in the map, the areas in orange were under control of the Normans. Areas in what are now England, Wales, France, and Ireland. Civil law developed in ancient Rome. The Romans controlled many lands surrounding the Mediterranean Sea as well as beyond. It was the Roman Senate was originally responsible for making those laws. And with such a large area under its control, it's easy to see why the Roman civil law system spread as much as it did. Now let's define the two. In common law systems, judges decide cases based on legal precedent rather than just codified laws. Judicial precedent shapes the law, and this can be found in countries such as the United States, the United Kingdom, Canada, Australia, and New Zealand. Civil law, on the other hand, is based on a codified system of laws. The emphasis is on written laws as opposed to judicial precedent and case law. And it can be found in countries such as France, Germany, Italy, much of Latin America, and Japan. Now let's look at some common law definitions. Stare decisis is a Latin phrase that means to stand by things decided, and it's a cornerstone of common law systems. It dictates that courts should adhere to precedents established by previous decisions. Common law can be used in the interpretation of contracts. The example of Pacific Gas and Electric Company versus G.W. Thomas Drage and Rigging Company. In 1968, the court applied common law principles to interpret contracts and determine the parties' rights and obligations. Common law can also decide issues between federal and state court cases. As example, Erie Railroad Company versus Tompkins in 1938. The court addressed conflicts between federal and state principles in tort cases. In Lucas versus South Carolina Coastal Council, 1992, the court considered common law principles of property rights in the context of takings under the Fifth Amendment. All of these are examples of where common law is applied. Now, let's look at examples of civil law. The Code of Hammurabi, circa 1754 BC, was one of the earliest known legal codes and served as an example of civil law in ancient Mesopotamia. It consisted of a series of laws and punishments covering aspects of daily life, family, property, and commerce. And the code actually prescribed specific punishments for different offenses, establishing a system of justice based on written laws. Roman law began with the 12 Tables, a constitution which was later added on and served as the basis of Roman civil law, which was later compiled in the 6th century AD by Justinian in what's called the Justinian Code, or Justinian Codex, which was a compilation of all the Roman laws simplified and put into one manual. This served as a basis for the legal system for much of modern Europe. A more modern example of the civil law system is the Napoleonic Code of 1804. Also known as the Civil Code of France, it was enacted under the leadership of Napoleon Bonaparte, and it represented a significant reform of French law, and basically consolidated various legal principles into a single comprehensive code. And the code emphasized equality before the law, protection of property rights, and clarity in legal procedures, serving as a model for civil laws in many countries. Let's look at the sources of law for both of these systems. Common law is an adversarial system, where parties present evidence and arguments before a neutral judge or jury. It's the judge's role to oversee proceedings and ensure fair play, but he or she does not actively investigate or seek evidence. Civil law, on the other hand, is an inquisitorial system, where judges take a more active role in investigating facts, questioning witnesses, and directing the proceedings. The judge plays a more prominent role in uncovering truth and determining guilt or innocence. To further clarify the role of judges, common law judges have significant discretion in interpreting laws and shaping legal principles through their decisions. They rely on precedent, but have the flexibility to adapt legal principles to changing societal norms and circumstances. Civil law judges, on the other hand, have a more limited role in interpreting the law compared to common law systems. Their primary function is to apply the law as written, with less flexibility to depart from statutory provisions or legal codes. As far as legal traditions, common law emphasizes case law analysis, reasoning by analogy, and understanding the evolution of legal principles through judicial decisions. Therefore, lawyers in common law systems typically undergo pretty rigorous training, whereas in civil law, legal education focuses more on understanding statutory law, legal codes, and civil law principles. Emphasis is placed on understanding and applying the specific provisions of codified law rather than case law analysis. This typically means civil law systems have more common outcomes, with less judicial discretion as in common law systems. In conclusion, hopefully you can better understand the similarities and differences between common law and civil law legal systems. Thank you so much for watching this video from the Lyceum of History. If you liked it, give it a thumbs up and consider subscribing to the Lyceum of History for more information about the past.